All right, and here we are at the most controversial, stressful, curious time during the home selling process, and that is the home inspection contingency. Whew, getting here and being ready to go through this process takes a lot of emotional, mental, and sometimes spiritual power to push yourself through it. So don't let me alarm you by saying these things, but it is I'd say, the most climactic part of the real estate transaction process. And that is because you just don't always know what's going to come up. And it really depends on the personalities involved in the transaction as to how it all ends up going down and getting worked out. So let's just put on the table first and foremost that every inspection contingency gets handled based on how the contract or the attorney review letters are drafted. So what I will go over in this video is general, but what really matters to remember as I go through this video is that your transaction, when you're in it, might be different or handled differently. And that is because the attorney review letters control how everything flows. So generally speaking, the way the inspection contingency works is that the buyers will have their home inspections. Their home inspection or inspections may happen on different days because there are different types of inspections that the buyers will be having. The most common inspections that you can expect a buyer to have of your property are the general home inspection, which usually also includes a wood destroying insect inspection, which includes looking for things like termites, carpenter bees, carpenter ants, things like that. And the next thing is radon. Now, you probably had those things tested when you bought the home, so those should most likely sound familiar to you. Now, the next type of common inspection that you might see a buyer having, especially if you're not selling a condominium, but you're actually selling a house that is situated on land, is an oil tank sweep or an underground tank inspection. The next thing is buyers may be looking at the sewer line that runs from the street to the property, and that's if you have public water. If you have a well, the buyers may be testing the well structure. Now, a point about wells is that usually sellers are responsible for testing well water and providing clear well water test results. So that is something to be mindful of if you're selling a property that has a well. If you have a septic system, the buyers will definitely be having the septic system inspected as well. Well, so the next inspection that they might have is a chimney inspection. Those are all the most common inspections that buyers will be having. They may choose to have all of them or some of them, depending on their guidance they're receiving and depending on what they're really passionate about. But those you can expect them to have. Now, when it comes to what the buyers can request of you as a seller, is the buyers can, and this really goes back to the attorney review letters, the buyers can ask for things that are within the scope of the inspection contingency. So for the purposes of this video, let's just say the problems have to be legitimate and they have to be more than just a broken light bulb, right? Or more than just the window won't unlock itself, right? Generally speaking, they have to be repairs that impact like the safety of the home. But you may have, depending on how attorney review gets negotiated, the buyer asking for things that are basically just mechanical repairs that are needed. And a mechanical repair is a pretty broad term. So let's just say the problem has to be legitimate. It can't be cosmetic and it can't be aesthetic. So if the buyer's like, I really don't like the paint on the wall, or there's some chipped paint here, if it doesn't impact the functionality of the home, it is not fair game. And they cannot ask you to repair that. If they do, you can rightfully reject it and not be worried about the impact of it. Now, for things that are fair game, then what happens? So, generally speaking, the buyers have the right to ask you to make repairs. You are not required to make repairs to the things that they ask you for. However, if you refuse to make repairs, and those are things that are legitimate, and the buyer does not want to proceed unless you actually make those repairs, they will have the right to cancel. So, what that means is because the seller knows that the buyer has the right to cancel, and because the buyer knows that the seller has the right to say no, what that does is it sets the platform for what we all hope to be a good faith negotiation, where both parties work together to reach a harmonious resolution. Now, sometimes buyers may be willing to proceed if you say no to everything, but you don't know that unless you stand up for yourself. So it's important to talk to your attorney, to work with your lawyer, to make sure that when you respond, you're responding in a way that really is encompassing of your digestion of the risk of what can happen if you approach it a certain way, and that you're prepared for all the possibilities of how the buyers might respond. So sometimes the attorney review letters will add in things that are like, if the seller says no to fixing everything, the buyer will have the right to cancel no matter what, right? You can't say no and then the buyers say they want to cancel and you say, oh, I changed my mind, right? That's one way that things can come up in attorney review. Another way is the sellers might say buyers don't have the right to cancel based on our first response. So there's a lot of different ways that things can get written out so that there's added protections and some buffering. And that's where we can, kind of leave that discussion for when you're really in the middle of your transaction and not focus on that for this video. So another thing that is important to know is that when you're offering to respond to the requests, you can offer responses in two ways. One is you can offer to provide a credit to the buyer instead of actually making repairs, or you can offer to make repairs. The buyer may ask you for a credit, but you're not required to give them that. They may ask you for repairs, but you're not required to give them that. You could give them a credit if you'd like to. They will have to decide if they want to choose that or not. So there's different methods to resolving the inspection that don't just require you to make repairs right away. Now, there are some things that generally any buyer will not proceed unless this one or two or three things are done. So your lawyer, and this is something that we guide our clients through, is when there are specific things that do come up that we know that any buyer, unless they're like an investor or they're foolish, right, that anyone will want this fixed, we will give you that guidance and we'll provide that information for you so that you have that and that responding negatively could lead to that transaction falling apart. And you also need that expectation managed, right? That if I say no to this and this contract gets canceled and then I go back to the market, is it likely that I'm going to find a buyer who's okay with this problem? So there's a few things that can come up that meet that category threshold. And so our office will be there to guide you through that process. For the purposes of this video, some of those things are high radon, actual evidence of termites, an underground storage tank being located on the property, a failed septic system, the well not passing primary, secondary standards. Like, these things are really big things that any buyer will likely want you to fix. So having a plan in place to determine what you're going to do is important. Another tip that you can do if you are definitely in preparation stages right now, let's say you've just listed the home or you're not even ready to list it, you can do what's called a pre-listing inspection with a home inspector. And you can make sure that you have an idea of what's going on in the property and you can actually repair some of those things prior to having any buyer do a home inspection so that you can get a leg up on minimizing the risk of your transaction falling apart. Now, a word to the wise is that if you do that listing inspection and certain things come up, now you have knowledge, right? So you have to then disclose some of those things depending on what they are during the attorney review process, if you remember what we talked about in one of the first videos. So let's say we put into the universe, right, that you actually had a successful negotiation for the home inspections. All of the reports came in from the buyer and we satisfied everything in terms of coming to a resolution of what they want. Now what happens? So what gets agreed upon gets memorialized in writing between the attorneys. And if it's a credit, that credit will go to the buyer on closing day. You don't actually give them cash. It just gets added as a deduction of what you would otherwise take home as your proceeds. And the buyer will just bring less to the table for closing day. And if you are making repairs, those repairs will have to be done prior to closing unless there's some other agreement. And on closing day, the buyers will go do a final walkthrough and make sure that the repairs are done. So that's what happens. And it's a day to celebrate for sure. It's a major milestone to conclude the inspection contingency. And it's a really, really big thing to accomplish. So we'll say congratulations on getting there. And in the next video, we're going to talk about satisfying the buyer's financing contingency. And I can't wait to chat with you about that stage because there's some nuances in there that are more than just the buyer getting their mortgage that we definitely want to focus on and give you some insight into so you know what to expect in your transaction. So I will see you there.